Hi everyone, I welcome you back to our channel. This is Legal Mindset at the bar, and today we are going in for the fundamentals of criminal law. Uh, we are going to look at the principles of criminal law. So we shall start with the burden of proof. I urge you to subscribe such that we continue with our topic on burden of proof. So by the end of this session, you should be able to define the burden of proof as a layman. You should also be able to give the general rule under the burden of proof. You should know the case which laid down the burden of proof. You should know the exceptions to the burden of proof. And as a bonus angle until this video, where I shall take you through the fundamental legal principles governing the burden of proof. So, what is burden of proof? As a layman, the burden of proof means the duty to prove the existence or non-existence of a fact. Now, if you go to the Black's Law Dictionary, 9th edition, at page 217, it defines the burden of proof to refer to a party's duty to prove a disputed assertion or charge. As a general rule, the burden of proof lies on prosecution, and this principle was laid down in the case of Wilmington versus DPP, where Lord Sankey clearly stated that throughout the web of English criminal law, one golden thread is always to be seen, that it is the duty of prosecution to prove the accused is guilty. This means that prosecution has a duty to provide evidence against uh, the accused to prove that the accused is actually the person who committed the offense. Otherwise, the accused will be acquitted. By acquitted, we mean that the accused will be let to go. So, prosecution has to prove that the accused is guilty at the standard of beyond reasonable doubt, as laid down in the case of Miller versus Minister of Pensions, a case of 1947. Therefore, the burden of proof lies on prosecution to prove that the accused is guilty beyond reasonable doubt. That gives us the principle of presumption of innocence, because if prosecution has a duty to prove that the person is guilty, it means every person in criminal cases is presumed to be innocent until prosecution proves that that person is guilty beyond reasonable doubt, or until that person pleads guilty under Article 28, Clause 3, Paragraph A of the 1995 Constitution. That is the presumption of innocence. So, what is the position of the law on the burden of proof? If you go to section 101, subsection 1 of the Evidence Act, cap 8, it provides that whoever desires any court to give judgment as to any legal right or liability dependent on the existence of facts which he or she asserts must prove the existence of those facts. It means if you are reporting someone, you should prove that they are guilty of what you're reporting them for. And in criminal cases, it is prosecution, it is state against the accused. It means the state has to prove its case beyond reasonable doubt. If you continue to section 101, subsection 2 of the Penal Code Act, cap 128, it provides that when a person is bound to the existence of any fact, it is said that the burden lies on that person. If you allege a matter, you must prove it. The bottom line is the general rule is the burden of proof lies on prosecution to prove beyond reasonable doubt as the standard of proof. Now, we shall continue to the exceptions of the burden of proof. What are the exceptions to the general rule that the burden of proof lies on prosecution? So, we are going to look at a number of exceptions, and I urge you to be very attentive because these ones are so technical but paramount to your understanding of the burden of proof. Now, under these exceptions, we have the statutory exceptions, we have the doctrine of recent possession, we have false checks, intoxication, insanity, provocation, alibi. So, to begin with, statutory exceptions. This is where a specific statute comes in and says the burden shall lie to another person in some offences. And if you go to section 103 of the Evidence Act, Cap 8, it provides that the burden of proof as to any particular fact lies on that person who wishes the court to believe in their existence. That is the general rule. The section goes on to say, unless we are now going on our exception, it is provided by any law that of uh, proof of that fact shall lie on another particular person. So that is the position of law on statutory exceptions. It is, however, important on this juncture to note that the burden which shifts to the other person is not the entire burden. It is called a provisional burden, a burden of rebuttal. Take an example, you bring a defense to court, say alibi. A provisional burden comes to you to say that I was not at the scene of crime. Then the other burden goes back to prosecution to place you at the scene of crime. That is called the burden of rebuttal, the provisional burden. So let us now look at the doctrine of recent possession. This is common in circumstantial evidence, where a person, for example, is deemed to have stolen goods, or a person is deemed to have stolen goods because that is recent possession. In Uganda, they say, you say the doctrine of recent possession. Where you're found with stolen goods, you're deemed to be the thief. So the provisional burden, the burden of rebuttal now comes to you to say that no, these goods belong to Counsel Joshua. That is the provisional burden. And it will the burden will go back to prosecution to assert that the goods belong to you. Or bring in the other accused you have alleged to be the owner of goods. But if you're found with stolen goods, court will presume that the goods were stolen by you, or you know the person who stole the goods. That is the doctrine of recent possession. Now, let us look at intoxication. Under intoxication, Section 12 of the Penal Code Act, Cap 128, provides for intoxication. And when proving intoxication, a provisional burden will come to the defense to prove that the intoxication was involuntary. And after, the burden will go back to prosecution to adduce that it was voluntary, because for them they want to convict you. But a provisional burden will come to the defense to prove that it was involuntary. Let us now continue with another exception, that is insanity. You can call it the defense of insanity under Section 10 of the Penal Code Act, where the law presumes every living person, every person who moves, to be sane. So, if you go to the case of Bratty versus Attorney General for Northern Ireland, Lord Denning stated that it is the duty of the defense to prove that insanity, like the person was affected by a disease of mind and their actions were involuntary. That is the provisional burden that goes to the defense. Now, if we continue to look at, let me see, alibi. This is so keen and technical. Where the accused raises the defense of alibi, it becomes a battle prosecution. The burden has now shifted to the defense to say that the accused was not at the scene of crime. Now, we said it is only a provisional burden. The burden will go back to prosecution to place them at the scene of crime. And when prosecution fails to do the same, the accused will be acquitted. The accused will be let to go. I urge you to look at the case of Uganda versus Dr. Agre Chinji, where Dr. Agre Chinji was acquitted on grounds that prosecution failed to place him at the scene of crime, where his wife was killed in Ibuziga. For him, he said that he had been called to a certain place to act as the guest of honor at the time his wife was being killed. You can also look at some cases where the defense failed to work, where the defense raised, the burden went to the defense, and they pleaded that I was not at the scene of crime, but however, prosecution successfully rebutted it by placing them at the scene of crime. Can look at the case of Akbar Godi, Akbar Hussein Godi versus Uganda, where he pleaded that he was not at the scene of crime, but prosecution went on to use the shoe prints to locate Akbar Godi at the scene of crime, and the MTN telecommunication networks, which shown that his phone was in the place where his wife was being killed. Those are the exceptions to the burden of proof. So that was our video on the principle of criminal law, that the burden of proof lies on prosecution. I urge you to subscribe, share if these videos are helpful to you. Thank you very much.